Hi, everyone. My name is Beverly Allen. I am a local family law attorney in Tacoma. I've been practicing family law for 13 years. This video is made in connection with the Pierce County Law Library for their Vibrant Communities video series and focuses on termination or disestablishment of parental rights. And it will be helpful for either self-represented litigants or for newer attorneys who are delving into the termination area. So there are three different ways that parental rights can be terminated or disestablished. The first and possibly the more common one is the dependency petition process. So where a child has been removed from the home and found to be dependent, either the state or in some cases the other parent can file a petition to terminate the parental rights of that parent who is alleged to be unfit. And you can find the forms that you need on courts.wa.gov. There will be a link to the termination of parental rights if you are seeking to do so following a dependency filing. Most people, though, find themselves in the situation where the state is moving to terminate the parental rights. And in the case where the state is moving either for dependency or termination of parental rights, there is the right to counsel for litigants who fall below a certain income threshold. So if you are at the receiving end of a petition to terminate parental rights, you should already have been screened to see if you're eligible. And at the same time, if you are seeking to terminate parental rights and you are the other parent, then you should be aware that the parent whose rights you are seeking to terminate does have the right to counsel. If they are under a certain income threshold, one can be appointed for them. The second basis to terminate parental rights is in the step-parent adoption proceeding. So it's RCW 26.33. And the law library does have packets for adoption. There will also be a link to, or you can request the petition to terminate parental rights where the adoption is contested, is contested, but the law library's forms are meant for where there's an uncontested adoption. So there are two different types of forms, and where the termination is not contested, there's another form called consent to termination of parental rights. And the most common situation we see step-parent adoptions fall under is where the biological parent has been out of the child's life for some period of time, usually 6 months or longer, and quite often where that same parent owes child support. And in order to incentivize that parent to sign over their parental rights, to terminate their parental rights, then it's often an incentive to discharge the child support arrears that parent may owe, which the other parent who's seeking to terminate the rights, usually but not always the mother, can specifically request the state discharge any arrears that are owed. So that's often an incentive, but the biological parent doesn't always sign that consent. Sometimes you can't find the other parent, or sometimes they oppose that. So in the situation where you can't find the other parent, there are alternative service methods. You can request the ability to serve the other biological parent by mail, or you can request to serve by publication, or you can hire a private investigator to do a skip trace and to see if they can find the address. Then that will help you serve the petition and mail over the consent to terminate. Now, I have developed forms, and you can get a link to the petition to terminate that I've developed where the other parent is not consenting. And in that case, there are two possible outcomes. Once you've located the other parent and you've served them, then the other parent may fail to respond to service. If that happens, then you can request a motion for default, which is where you say to the court, hey, the other parent has not responded. I want to move forward, and the court can grant an order of default. And then the rest of the case can proceed. You'll have to have a home study. In Pierce County, we do have an adoptions coordinator. She can be on the case and assist with helping develop that case and do the home study if there is either a default order in place or a consent to adoption. If it is contested, you will need to find your own social worker to complete that home study, but you can still use the same forms in the packet. The third way of terminating rights is actually where rights were established, but the parent who's on the birth certificate then asserts a claim of fraud or duress or mistake of fact. So let's say that a biological father was, or that a acknowledged father, someone who has signed the acknowledgement of paternity, finds out later that there's a chance that the mother lied to them about the paternity. In that situation, that parent can file a petition for the adjudication of parentage under RCW 26.26A, and those forms are also available at courts.wa.gov. They are also available at the law library for a fee of $40, which gets you not only the forms that you need to use, but also we'll have some checklist and an index of the instructions. So you'll have to prove, you'll have to assert in the petition for adjudication that there was some sort of mistake. You thought you might be the father, and then it turns out the time frame doesn't match up, or you learned recently that the person who's the mother was sleeping with multiple people at the same time as you, and so there's a chance that you may be wrong about parentage. In that case, as long as the child is under the age of 4 years old, you will be able to open up a petition for adjudication. I do not recommend waiting that long. You should also know that the adjudication of parentage may be denied if you are not able to meet those requirements to get the genetic test done in time. So it's better to act sooner. The other thing that you should know is if the genetic test determines that you are not the biological parent, and yet you have held this child out as your child, there may be some de facto parentage obligations that kick into place. But it's often a useful tool for people who discover that there are other genetic fathers. So you can essentially be relieved of your parental duties and obligations if it's pursuant to a petition for adjudication and you both make a credible explanation for why you were mistaken as to fact, and there's a genetic test that shows that you are not the child's father. So that's the petition for adjudication. Under an adjudication of parentage, the birth certificate can also be amended if the parental rights are terminated. That is often done by reaching out to the Department of Vital Statistics with the court order that terminates the parental rights and orders changes to the birth certificate as well. So if you have questions on how to proceed from here, first of all, I highly recommend that you consult with an attorney for your particular case. You can find attorneys on the Tacoma-Pierce County Bar Association. There's a lawyer referral line. You can also go to Tacoma Pro Bono if you meet income guidelines. And then in terms of getting materials and resources to do this yourself and to represent yourself, you can look at other videos on the Vibrant Community video series. You can also go to courts.wa.gov and research your options. There will be a link that has more detail regarding the process for termination and the different bases for termination, which was put out by Washington courts, and that will be available to you as well in the comments or links from this video. Thank you.